So today, Justice James Omotosho of the Federal High Court in Abuja nullified the 800 billion budget passed by the Edison Ehie-led group of the Rivers State House of Assembly, and was signed into law thereafter by the Rivers Governor, Siminalayi Fubara. The court also upheld the suit filed by the Assembly and Speaker Martin Amewule against Governor Fubara, which sought an order of injunction restraining the governor from frustrating the Assembly under his leadership as Speaker, among several other prayers. So, a little background. On the 13th of December 2023, in the heat of the protracted political crisis rocking the state and the demolition of the Assembly complex, Governor Fubara presented the 2024 Rivers budget proposal of 800 billion naira to 5 members of the State Assembly led by Honorable Edison Ehie. The presentation was done at the Government House in Port Harcourt following the demolition of the Assembly complex by the state government, and after a court restrained Ehie's contender, Martin Amewule, from using the Assembly complex. Ehie and the other pro-Fubara lawmakers passed the budget estimate. The governor signed the bill into law, saying it is aimed at promoting economic development through inclusive growth and addressing socio-economic inequality in the state. Meanwhile, the Rivers APC caretaker chairman, Mr. Tony Okocha, has held the judgment of the Federal High Court of Abuja, avoiding the budget presentation by the Governor Sim Fubara to the Edison Ehie group of the Rivers State House of Assembly at the height of the political tension in the state. Mr. Okocha is in an exclusive interview with Channels Television in Port Harcourt, notes that he had earlier warned the governor to be cautious of some of his decisions not to put the state into crisis. Take a listen to him.
What constitutes an assembly is not the building. It is the human beings, the assembly members elected. And for an assembly to sit and be seen to be properly, it must have 1/3 of the members sitting and meeting. And 1/3 of 31, conservatively, is 10. So even discussing with 4 members of the assembly and submitting to them or presenting to them a document as all important and as crucial as the budget is criminal in the first place. Okay, so the judge was right. In fact, like I said, it's commonsensical that you can't do a thing like that.
All right, then. So things are developing so fast. Then we're now hearing and understanding that there is a new development coming from the courtroom. Justice Joyce Abdulmalik of the Federal High Court in Abuja has now ordered all parties in the Rivers State Assembly crisis to maintain status quo. The ruling directs the parties not to make further steps pending the determination of an application that is seeking to stop Governor Fubara from representing the already passed 2024 budget of the state before the Legislative House. Well, let's get some insight into this. We need an experienced lawyer, not only a lawyer, someone who has experience in politics of the legislature. I'm being joined by a former member of the House of Representatives, Dr. Samson Osage, a legal practitioner, as a vice president of the African Bar Association West Africa region. He joins us virtually from Abuja. Thank you so much, Honorable, for joining us. It's good to see you. Give us a sense, because this is not the first time that we're seeing this kind of crisis in Rivers State, and especially one that involves arguing the number of lawmakers sitting in the state. We've seen this happen in Oyo State, we've seen this happen in Bayelsa, we've seen this happen in Kogi, even in Edo State, this has happened. But what does this particular one teach us? What can we learn from it?
Thank you, Shehu, for having me this evening to share some thoughts on the legal conundrum that is just now confronting the Rivers State government, particularly the governor of Rivers State. And for this purpose, I need to draw attention to the fact that 3 sections of the Constitution are quite apt in discussing this subject matter. Section 91 of the Constitution, Section 120 of the Constitution, and Section 121 of the Constitution. Beginning with Section 91 of the Constitution, which defines what a House of Assembly is. It says that the House of Assembly shall consist of at least 3 to 4 times the number of this members of the House of Representatives from that state. So in other words, the House of Assembly is not the building, it's not the structure. It is the number of persons elected to represent the different constituencies. In Rivers State, for instance, we have 32 elected members of the House of Assembly. And it is expected under Section 91 of the Constitution that not more than 1/3 of that House shall have the authority to conduct legislative business. So what is happening now is exactly what Governor Obaseki had perpetrated in his entire 4 years as governor of Edo State. Now, in Section 121 of the Constitution, it says the governor shall lay before the House of Assembly. So now, if Section 91 defines House of Assembly to mean a House of Assembly that can be made up of 3 to 4 times the member, or a 1/3 that can take decision, it means that 4 people cannot form a House of Assembly. Therefore, legally speaking, as at the time Governor Fubara presented the budget before 4 members of the Rivers State House of Assembly, it was not only an illegality, it was an unconstitutional act, both on the part of the governor himself and on the part of the 4 legislators who partook in that session. And what is even more, Section 120 of the Constitution made it clear, and that is why Governor Fubara was very careful. You cannot spend any money out of the consolidated revenue fund of the state unless the issuance of that money has been authorized by a law passed by the House of Assembly. So, legally speaking, all the expenditures that Governor Fubara is making in Rivers State today are not supported by law, are not supported by the Constitution. In other words, he is acting otherwise the Constitution in the administration of the revenue and finances of Rivers State. And that can be a ground of impeachment in due course. I do not think that Governor Fubara is having legal advice, proper legal advice. Otherwise, I would agree to the terms of political settlement they had some months ago. It shouldn't have been difficult for him to represent that budget before the fully constituted House of Assembly, so that he can cross the hurdle, of having the budget passed by a properly constituted assembly. So for Governor Fubara, it is a very testy time, and he must be careful not to continue to live in denial that he has breached the Constitution of the Federal Republic of Nigeria, and must be very careful, because the House of Assembly itself had granted him the only branch to come and submit that budget, and yet he had continued to live in that breach, and I don't think he has any more chance to continue. The court having ruled, if I were Governor Fubara, I would represent that budget because it doesn't have one before it, so that he cannot continue a constitutional breach. He cannot have a budget passed by 4 people. Exactly.
But if you look at it, so let's take it from where this crisis started from. There was a court ruling that established and acknowledged the Edison Ehie group of the House of Assembly. You've analyzed the number that is recognized by the Constitution of the Federal Republic of Nigeria. In that sense, if the governor is going by the ruling which recognizes the Ehie's group as the authentic leadership or the House of Assembly, where is error there?
If the court recognizes the Edison Ehie, recognizes Edison Ehie as the lawful Speaker of the House, the court did not recognize the 4 members together with Ehie as legally constituting the House of Assembly. There are 2 different things here. The first was, who is the authentic Speaker? They went to court and the court said it was Ehie. But they didn't go to court to define what constitutes the House of Assembly. So the initial ruling recognizes Ehie as Speaker did not validate Rivers State House of Assembly with 4 members, and no court can validate that, because the provisions of Section 91 of the Constitution is sacrosanct. So there is a difference between that. If he had gotten the proper legal advice upon signing the terms of agreement which they did, and the House of Assembly, coming back to where they started from with the current Speaker, offering an olive branch for him to represent the budget, he would have taken that opportunity to represent the budget, and the ruling of today will have had no place. I will advise that he doesn't attempt to go beyond this stage. He should represent the budget before the legally constituted House of Assembly of Rivers. And then go ahead, because he's not likely to be fortunate, in this legal tangle that he has found himself.
In all of what is happening, yes, these are legal issues because it's brought before the court, but these are largely political issues, and also you can imagine how the political angle to these things will arrest the situation and stop it from moving forward. So there are those who will also imagine that, yes, the President, Bola Tinubu, intervened in this matter. There is a peace process, that everyone should calm their nerves and not go to court. And, how do you take, or what's your take on the perspectives of the President, the agreement of the parties in the peace process?
Well, for me, politics is a game of give and take. The peace process was wholly accepted by Governor Fubara, and indeed all the parties. And they began to implement, except of course that he has refused to go and present the budget. So, but he has recognized the speakership of Amahwe, and the Amahwe-led parliament, the House of Assembly of Rivers State, made up of over 20 members, over 25 members, have since taken over the reins of legislative duties in Rivers State. If he has recognized them and representing the budget was part of the agreement, why has he not done so? So, as far as I'm concerned, Mr. President has played the role of a father in order to bring sanity, to the entire political system in Rivers State. But the parties have remained defiant one way or the other. So I believe that the parties have a duty to allow peace reign, follow the law, and follow the agreement to which they have signed. If they don't do that, then it is no longer the president that is the problem, or that the intervention of the president would have made no impact at all. And it is in their elected self-interest and for the interest of peace, security, rule of law in Rivers State that they should follow the procedure, hook, line, and sinker, so that we don't get to a stage where we are now, that Fubara is to be cited for constitutional breaches. And one of the grounds that can lead to impeachment is a breach of the Constitution. When you spend money belonging to the state without the authorization of your parliament, then you are in gross violation of the ground norm, which is the Constitution of the Federal Republic of Nigeria, and you can have no defense to that. So he must save himself from the impending catastrophe that hang on his neck like the sword of Damocles.
So you will see now that there is a more problem brewing, because from the courtroom of Justice Joyce Abdulmalik of the Federal High Court in Abuja, the court has ordered all parties to maintain status quo. And the aggrieved members that have gone to court include River State House of Assembly member representing Bonny State constituency, Honorable Victor Okonjumbo, Senator Bernard Birabi, Senator Andrew Uchendu, Rear Admiral Fingesi, and Ankyo Briggs, and Emmanuel Dehima. Their lawyer is Luka Diajulo, and their prayers are that the court should unseat the 27 lawmakers who moved from the PDP to the APC. This is another fundamental issue in the old dynamics. And he's saying, look, whatever that is happening, all parties should maintain status quo. How do you interpret this, Dr. Osage?
Maintaining status quo can be an interim order granted before a substantive application before the court, is heard and ruled upon. So it is an order that is not likely to last in perpetuity. In other words, you cannot tell at the moment what the final order it will be when the substantive motion on notice will be taken at the next hearing. But what is more important is that regardless of this suit that you have just talked about, the other ruling of the court invalidating the presentation and passage of budget and signing of the budget of 800 billion for Rivers State has now received the hammer of the court, to the extent that that budget is invalid because it was not properly, or was not passed by a properly constituted assembly. That is a much more greater issue right now than the issue you have just raised. And I want to believe that those who have gone to court at the moment, to ask the court to unseat the 27 members, on grounds that they have defected to another political party, are going to be facing an uphill task and will not be doing good to the governor if they continue in that trajectory. So, at the moment, what is even more important and more tangential, to Governor Fubara's hold on governance in the River State is the budget that he's implementing. He is implementing a budget that has not been properly passed by a legally constituted assembly.
So Dr. Sagi, what you will be advising Governor Fubara is that he should not touch the budget. He should not touch the money that is unappropriated for until this case has been fully determined.
No. What he needs to do is to seek a political solution, ask those who have gone to court against the assembly members to withdraw their matter, and then he represents the budget. That is the easiest way out for him under the circumstance, so that he can represent the budget and stop continuing in the violation of the Constitution.
But there are those who say he should not represent the budget. And there are those who say, look, this is a violation, going to court is a violation of the peace process, to not represent the budget, fight is on. In fact, there are those with the argument that in the eye of the law, those 4 or 5 lawmakers were the lawmakers of the House as far as the court was concerned at that material time. And in that sense, whatever they did was legal and binding.
That argument will fall flat. That argument will fall flat in the face of Section 91 of the Constitution. As at the time that budget was presented to 4 lawmakers, there was no assembly as such. So let's even assume that the 27 members of the River State House of Assembly that defected to another party loses their seat. It meant that at that material point in time, there was no assembly, because the Constitution does not recognize a number less than 1/3 of the assembly as capable of exercising the powers of the legislature. It is clear. The Constitution we are talking about, we are not talking of a statutory another law made by the assembly. We are talking of the ground norm. He said the House of Assembly shall be made up of 3 to 4 times number of the legislature. It shall not be less than 32, 24. It shall not be more than 40. And 4, by any means, cannot constitute the House of Assembly under the ground norm of the Federal Republic of Nigeria, which is the 1999 Constitution as amended. So that their argument that only 4 members constitute the Assembly will fall flat in the face of Section 91. And there is no way any court can validate that the act of passing a budget by 4.
So in this sense, it's a real impasse, because the case that Kayode Ajulo is representing the plaintiffs in another courtroom in the same federal high court on one hand is there. The case in which the substantive case of this budget brought to the court by the members of the House of Assembly is on one hand. And you have said tonight that for the governor to be able to have a headway, he needs to seek a political solution to this. But in that sense, you look at it, who bears the brunt in all of this?
The buck stops on the table of the governor. Like I said, he is working on a very tight rope just now. River State, by the ruling of today, has no budget. So if he spends a penny of the revenue of River State, whether from the internally generated revenue or from the federal allocation, he is doing so in gross violation of Section 120, subsection 1, 2, 3, and 4 of the Constitution of the Federal Republic of Nigeria. And that is gross misconduct, which is capable of leading to his impeachment. So he shouldn't provide his adversaries with weapons to fight him.
But fundamentally, Dr. Sagi, this is a brainchild of a political feud with his godfather, Nyesom Wike. That is the primary cause of all of this problem. And so the people of River State will be bearing the brunt in all of these. The old dynamics is that there is a Nyesom Wike on one hand and there is a Fubara on another hand. And in all of this fight, it does look like the grass is going to suffer. If there is no budget, governance is going to be at a standstill.
Sure. And that is why the governor, as the chief executive officer of the state, must do everything within his powers to ensure that the exercise of his powers are not hindered by any constitutional or legal conundrum, such as he has found himself. Regardless of the political interpretations to what is going on, whether there's a godfather somewhere or not, he must keep his eye on the ball to ensure that in the course of this imbroglio, he is not found wanting as violating any law of the land, not to even talk of the Constitution. So it is in his own interest, and it is in the interest of the entire Rivers people, that the political solution that was midwifed by Mr. President be allowed to see the light of the day.
Well, it doesn't look like, and this is perhaps how I want us to wrap this up in 30 seconds, Dr. Osage. It does look like the intervention of President Tinubu is not working. It's not gaining the right result. Although it worked to a large extent, but with what has happened today alone, 2 court rulings or an order of court are looking like it has escalated the problem the more. Would they have to go back to President Tinubu to revisit the peace process? Or if you were President Tinubu and you are hearing this, what would you do?
President Tinubu is not the governor of Rivers State. He's the president of Nigeria, and he has a responsibility to govern this nation, including all the subnational government. His intervention is on black and white, and I think that the parties to that agreement must come together to save Rivers State from unnecessary hits and unnecessary distraction. It is not in the interest of any of the parties. It is not in the larger interest of the people of Rivers State. Above all, it is not in the interest of the governor of the state himself, who must ensure that he navigates his way out of this crisis by not giving himself up to be found wanting of breaching the Constitution or any law of land.
Dr. Samson Osage is a legal practitioner, is the vice president of the African Bar Association Western Region, and a former member of the House of Representatives. Thank you so much indeed for your time and the legal insight that you have given to us on this matter. Thank you so much indeed.
Thank you so much, Seun, for having me.
I appreciate it.
God bless you.